Welcome back to Constructive Uncoupling, the podcast devoted to amicable divorces. I'm Judy Weigel, your host and amicable divorce expert. Why? Because that's all I do, amicable divorces. Today's podcast is about getting a divorce and the options you have in filing. There is no one divorce suits all. That's the first thing you have to know. Every divorce is different because the people involved in the divorce are different. And because of that, you need to know which option suits you best. So I'm going to do two things in this podcast. I'm going to list the players involved, the people you can choose to help you get through the divorce, and the processes that go along with each option. So here we go. The players. We have attorneys, legal document assistants, and mediators. Let's start with attorneys. As much as people fear attorneys, both financially and out of fear that attorneys will do things that will cause them irreparable harm, they should and can be used for legal information and counsel. This is how important attorneys are. You really have to talk to an attorney to get your legal rights. And this is somebody who will look at you individually, look at the context in which your marriage occurred and the aspects of your marriage that need to be dealt with in order to move forward. And they will give you your specific legal rights. This is so important, and it's really worth the 1 or 2 hours at whatever their hourly rate is. This is how important it is to sit with an attorney. Unless you have absolutely nothing, no children, no assets, no debts, okay, then maybe not an attorney. But if you have any assets, any debts, and certainly if you have children, you really need to speak with an attorney, because you need to be educated. Now, I do realize that you can look online and you can look at the laws that affect your state in your divorce, but honestly, there's caveats and nuances to the laws, and it is so prudent to spend that money to speak with an attorney. So the attorneys are the ones that will give you legal advice and counsel, and nobody else should be used for that. Number 2, we have a category called legal document assistants. I happen to be a legal document assistant. A legal document assistant functioning under the acronym LDA. These are paralegals on steroids. Now, legal document assistants are not allowed to advertise themselves as paralegals to the public. They're only allowed to advertise themselves to the public as legal document assistants. But in order to become one, you need to be a paralegal first, and then you have to get a surety bond in at least $25,000, at least in California. You do have to research the laws of your state if you live outside of California, but in California, which is where I work in Los Angeles, legal document assistants have to be paralegals first, then they have to get a surety bond, then they have to get a legal document assistant license. And this allows them to file for amicable divorces without an attorney overseeing them file. So legal document assistants can get you divorced by filing all the correct forms in the order that they need to be filed in order to secure a divorce. That's really important, in the order they need to be filed in. And when we get to process, we will talk about that. Legal document assistants typically work on amicable divorces, divorces that are fairly easy to file for people who can communicate with each other enough to get through the paperwork and to make settlement decisions, and who don't think the other spouse is hiding significant assets or debts, or in marriages without domestic violence. So A legal document assistant has to work in a neutral capacity. And they really do have to work with people who are able to communicate with each other, because if you can't, this option doesn't work for you. Legal document assistants can either work with both spouses in a neutral capacity to take the information you give them and fill out all the court forms for you, or they can work with one spouse when typically the petitioner has already gone and filed maybe through an attorney, and the respondent doesn't want to use an attorney, at least not yet. They can go to a legal document assistant to file a response, to go through the disclosure process, but maybe when it comes time to make settlement decisions, maybe you have to use a hybrid and call an attorney in at that time. But a legal document assistant, like me, I really prefer working with both people, but I will work with only one person if required. And to be clear, a legal document assistant takes the place of an attorney filing for a divorce. It does not replace an attorney giving you legal rights or counsel. And I have to say this again, because a lot of times when people hire me, they think I can do everything as a legal document assistant. And that's not true. I need you to go to an attorney, get your legal rights, get some legal education, and then come to me to file. And there's no reason why you can't keep an attorney on the side for legal counsel while you're working with me filing for the divorce. The most important thing about legal document assistants is that they have to keep their neutrality. So please keep this forefront in your thinking when you're considering using somebody like me. 3, mediators. Now, as much as people like the idea of having mediators completely take care of the divorce, mediators only negotiate settlement terms. So this wonderful phrase that I hear, mediate, don't litigate, is a great concept that has fast become a popular trend in divorce, at least in California. More so now, people like to say, I want to get divorced by a mediator. So it went from mediate, don't litigate, which is fabulous. Then it morphed into, I want to get divorced by a mediator. But mediation on its own can't get you divorced. The mediation process helps you negotiate a settlement. But unless the mediator is also an attorney or a legal document assistant, you'll need either a legal document assistant or an attorney to help you actually file for divorce at the courthouse in order to receive a divorce decree. So mediators are what I call, seriously, angels of communication. And these angels of communication will help you negotiate your settlement by guiding you through conversations that you can't get through on your own, and participate with you in a brainstorming session trying to creatively come to a solution that works for both parties. And this is all done in a confidential environment in which you can try out ideas for settlement. So mediators, the gift mediators give you is that they can teach you how to communicate. And they can provide to you creative solutions that it's just too hard to get to on your own because you're stuck in emotion. And when you're stuck in emotion, you're stuck looking at this problem to solve called settlement through one lens only, and that lens is your own needs. What a mediator will do is listen to both people and listen to what's important to both people and start giving you back options that you can't see. So it's very interesting when people come into my office to mediate, they say, Judith, this is really difficult. We're probably never going to get through this, but we want to try. So they will each present their side of, for instance, how do we divide the house? Do we sell the house? Who gets to live in the house? If we don't sell the house, how do we pay the other person their equity portion if they're not going to sell the house? And this is one of the biggest issues in a divorce settlement. But there are so many ways to deal with it. And just because of experience that mediators have, they can be great at giving you creative solutions. Communicating is the hallmark of mediation. You have to be able to communicate. If you can't communicate, if you can't sit in the same room together, or at least separated, can't be rational, then mediation isn't going to work for you. All right, now those are the players. Let's talk about the process of divorce. So here are the processes. You can have, and this is the ultimate adversarial divorce. You can have a litigated in-court divorce. And a litigated in-court divorce is a trial. And sometimes that's the only way you're going to get a settlement. Typically, people will have attorneys representing them, but not necessarily. You can go to trial without attorneys. If you have done your legal research, if you are comfortable speaking for yourself, you can go through a trial without attorneys. But when you have a lot of finances, assets and debts to deal with, and if it's a very complicated custody situation, you're really going to want attorneys working with you. Now, of course, this is the most costly in terms of finances and in terms of emotion. So I want you to remember this, because when you have to use attorneys, and when you have to, you have to. If you have minor children, just going through that highly emotional process using attorneys, it's going to spill over into the emotion of how you deal with your children. Please make no mistake about that. You really have to work hard not to let the high emotions of dealing with attorneys in a litigated divorce, you have to work so hard so that it doesn't spill into the parenting relationship of your children. So what attorneys are going to tell you to do is not talk to the other spouse in terms of the negotiated settlement. They really want to be the only people speaking to each other for you. Now, in certain divorces, this may be the right thing to do, but in divorces where you have to hire attorneys because there are just too many complicated assets and debts, but you're still able to communicate with one another, this can be the most harmful thing to you. Let me tell you a little story. So I met a woman at a networking event, and she went through a very costly and very long divorce with her husband. And she's now done with it. But here's the tragedy. They both had attorneys. That's not the tragedy. They both had attorneys, but he, the husband, really wanted to speak with her and branch off and just sit down and make the settlement decisions on their own, and then give those settlement decisions to their attorneys to write up. Well, she wanted to consult with her attorney first and did want to speak with her husband, but the attorney wasn't available. The attorney was not in the office, traveling, wasn't returning phone calls. And this is one of the hardest issues. You're going to have to get ready for this when dealing with attorneys. It's molasses. It really takes longer to communicate with them than you could possibly imagine. And this, and this response time is detrimental to an amicable process, even if you want to be amicable, but just feel that you want the oversight of attorneys. So what happened was he was chomping at the bit to really sit down and amicably talk to her, but she was uncomfortable talking with him because her attorney told her not to do it. Well, he was so offended and misread her reasons why, because she felt that she couldn't even talk to him and say, my attorney said that we shouldn't talk, but I want to talk with you. She's just not getting back to me. She didn't even, the wife didn't even feel comfortable doing that. So it really turned nasty. And they went to court, and they went to court, and they went to court. And it's only because her attorney didn't get back to her in enough time. Isn't that sad? So when choosing an attorney, you have to ask the attorney this question. How quickly do you get back to people? You need to know what their caseload is, because their caseload will dictate how quickly they get back to you. And if they are overloaded, and at the beginning of hiring them, you see that it's taking days and weeks to get back to you, you might want to consider another attorney. You need somebody that gets back to you within 24 to 48 hours. You really need that, because you're walking on an emotional tightrope, especially when you're looking at one of these high-end litigated divorces. Timing is everything. And when the emotional space exists for attorneys to talk for you and make some decisions, boy, they better be there ready to talk with you. And if they have trials backed up, you're not going to get return phone calls. Important for you to know. Flesh this out when you go to hire your attorney. So the in-court litigated divorce is hugely adversarial, and you do become distant. Distance is created by the attorneys, and you and your spouse become more distant. Maybe that's a good thing, maybe that isn't. But if it's not a good thing, it really will serve to undercut the divorce. And lastly, in the litigated divorce that goes to court, you'll have a judge that will make all decisions for you because you'll go to trial. Now, in California, it's a non-jury trial, meaning there is no jury. It's the judge, both of you, and then both of you and your attorneys if you have attorneys. But listen, if you have to go to court and a judge has to make decisions for you, it's the best way for you. Now, don't use that litigated divorce option as a threat. Use it because you need it. And don't worry that you need it. If you need it, you need it. And don't use the judge as a threat. I know it's going to happen. I know how the judge is going to decide. He or she is going to see it my way. How could a judge possibly not decide in my favor, given this, this, and this? That is about the worst thinking you could ever engage in. Judges cannot make emotional decisions. You have to know this. Judges have this environment of laws, these options and how they can rule on your case, your specific issues. In California, they're called benchmarks. And in family law, like in every area of law, in family law, judges are given a range of decision-making that they can use for any issue in a divorce. And there's case precedent to support how they can rule. And if we learned anything from Legally Blonde, the law is reason-free of emotion. Emotions can't get in the way of decisions. Well, divorces are all about emotion, aren't they? Yes, they are. And a judge cannot get emotional. So please be aware of this when you go into the lawyer versus lawyer litigated in court option. Number 2, we have the litigated out of court option. Most divorces do not end up in court. Most divorces are litigated out of court, and the attorneys will file a settlement agreement with your judgment package, and that's how you're going to get divorced. So you have attorneys, And more than likely, you will have a mediator in this type of litigated out-of-court process. You can just use attorneys and an individual mediator, or you can go through what we call the collaborative process. So the collaborative process is expensive, but you don't go to court. So it's a little more kind and gentle. The collaborative process, though, involves a mediator. Each party has attorneys to represent them. There will be what we call a forensic accountant at the table to really fine-tune the asset and debt division. Well, first of all, to look at the asset and debt value of what you have to divide, and then to look at the equal division of it. And then you'll have a therapist sitting at the table to deal with maybe a co-parenting plan if you have children. Or if you're just so volatile that you need a therapist at the table to be able to communicate, a therapist will be handy. It really will come in so helpful so that you can calm down and talk to one another. So this is costly financially, but you'll have more control over the settlement terms because you will be discussing it with a mediator. So in this type of litigated out-of-court divorce, the parties will receive necessary legal information from their attorneys. They'll have a mediator who works with the parties to help craft the settlement. And then in the collaborative divorce, a financial expert and a therapist. But the parties will maintain control over the settlement, and it's worth it. It really is worth it. Then you have number 3, what we call a pro-per filing. That means the couple represents themselves. So you have 2 options in pro-per filings. You have the option where you have professional help, like me, a legal document assistant, or you'll have a pro-per filing where you have no help. You'll do it yourself. So let's look at the option where you have help. You can hire somebody, you can hire me or one of my colleagues, a legal document assistant, to help you file, and you can hire a mediator to help you with settlement terms. But if you already know what you want to do settlement-wise, you don't need a mediator. You can really save yourself some time and money, especially if you can communicate. This is so wonderful. And even though I absolutely love mediating, if the couple can come to decisions on their own and they've received legal counseling from attorneys, I think this is the best way because you are totally in charge of your decisions. They're going to reflect exactly what you want, and there's nothing better than that organic process of decision making. But with the pro-per filing with professional help, you can have an attorney on the side in what we call limited scope counseling. You don't even have to do a retainer. You can just ask an attorney, can I pay you by the hour when I need your help? And that's fabulous. And then you control all the cost because you are in control of the amount of time that you use with an attorney. So filing with legal help, with professional help, is much less costly financially and much more emotionally humane because everybody is going to work towards just calming everything down if you get a little upset along the way. So a calm atmosphere is maintained by the professionals involved. A filing process is under the control of a professional, but it's also under control of the parties in terms of the timing. Maybe you need a little more time after you exchange your disclosure forms and before you have your legal document assistant write the settlement agreement. And sometimes space and time is needed, so you control that. And then lastly, the parties maintain control over the settlement. Now, if you use the version where you have no professional help, you can either go to the self-help centers at a courthouse. Now, most of them are not going to tell you how to file. They're going to give you a whole batch of forms, and they're going to say, do your best. Go online, read, and then just start filing. But here's where you're going to fall down if you don't have help. You're not going to know how to fill out the forms correctly. You're really not. as simple as they look at when you look at them, they seem to be when you look at them, they're just not easy to figure out. Not every option is available to you if you want special things, and they're just a little confusing to read. I mean, that's the best I can say. They're a little confusing to read. This option is fraught with landmines because without professional guidance in filing, lots of mistakes are made, either in the order in which you file, but in how you fill out the forms. You know, people think they don't have separate property or they don't have community property. So when they go to the petition, they fill out those sections incorrectly. And this comes back to haunt them when they complete their final forms. The final forms harken back and are reflective of the initial forms. So if they're not done right, the final forms aren't going to be done right. But there are some self-help centers at certain courthouses in Southern California where people are a little bit more involved in helping you. It just depends on where you go, but where you go has to comport with the address that you are filing from, you know, your home address. So I know there are online services that people use. I inherit a lot of people who have tried to use online services rather than going to the self-help centers of the courthouse. So, you know, do what you think is best, but you're going to get a lot of rejection. So filing really becomes a job at a certain point because you have to invest a lot of time in teaching yourself either through reading books or reading the websites in your particular city and state. When you start filing and you think you know what you're doing, then you're going to start getting rejections from the courthouse. Now, the rejections will tell you what to fix for the most part, but not completely. And unless you understand what the court is trying to communicate to you, you're going to get a lot of rejections and you're going to get stuck, and then you're going to call somebody because you're going to really need help. So there's a huge learning curve when you try to figure out how to file yourself. It's frustrating as forms get rejected, and you just keep falling in these landmines. There are specific reasons for employing specific professionals in your divorce process. So this is a recap. Attorneys should never be omitted from this process because they are the only professionals who are licensed to quote law to you. Knowing the law empowers you to make the settlement decisions that you'll be comfortable with throughout the divorce and once the divorce is filed. Now, as a recap, use an attorney to know the law surrounding your settlement points, get your legal rights, and have someone you can call throughout the divorce filing process when issues come up. And like for instance, a parent taking the child on vacation when the other parent is concerned for the child's safety or security. I want to tell you a little story. This is one of the most difficult things when you need attorney advice. So when you have children and you want to individually take the children out of the county, you have to get the other parent's permission. So I had a couple from a different country, and they were stars, superstars in the film business. The wife was going to what was considered the Oscars of that country, and she was going to get an award, and she wanted to take her son. Well, the husband said, no, this country is at war. You can't take our son there. Now that was a valid concern. But if you want to take your child to your parents and there's no war going on, and you have, as a family, gone to see your parents before, Yes, that would be unnecessarily withheld consent, and you absolutely need an attorney to help you through this. So attorneys are to be used either to completely represent you or as legal counsel if you want to use a legal document assistant or if you want to file on your own. Then we have how to use a legal document assistant. You use them if you don't want to spend a lot of money on a divorce. You use them to file only. You use them if you want somebody neutral to work with both you and your spouse. And you use them so that you can control the timing of the process to file and control of the outcome. And then third, how to use a mediator. You want to use a mediator to control the outcome of the settlement, especially in child custody cases where you want to talk through the issues, but you don't want a judge making a decision for you. You use a mediator to control cost, although people have spent a lot of money on mediation, I have to say. And I'm thinking of one couple specifically, well, several couples that came to me. They were on emotional roller coasters, and they came back a lot to mediate because with each mediation, we got farther down the road, but they needed to think about the settlement. They needed to, if they had children, and all of these couples did, they had to kind of practice through the co-parenting schedules, the co-parenting plans, to see if it felt right, and then they would come back to mediation to fine-tune. Or they were in such a highly emotional state that they couldn't even remember why they were making decisions. And we had to keep walking through the decision-making repeatedly, because it just wasn't sticking. But still, they didn't end up in court. They all had attorneys on the side, and eventually we got through the filing process and the mediation process. But you also use mediators to maintain a calm environment throughout the settlement process. And that's what mediators will do. They will help you calm down, not as a therapist, but just working with you on your communication skills. And that's where it's at. When you want to use a mediator in a mediation process, you really have to change the way you communicate with each other. That is the central point in mediation. And you cannot think the other is hiding assets. If that's the case, you got to go to an attorney. And a forensic, and an asset researcher. We'll get to those people in another podcast, but I did touch on a forensic accountant when you're in the collaborative process of settling a very high-end asset and debt divorce, or when you're going to trial. But then there's this person called an asset researcher. And if you really think your spouse is hiding assets, you go to an asset researcher. But anyway, those would be the only things that would not work in a mediation. So in conclusion, whatever option you choose, and with whomever you choose to work with, make sure it suits you. Make sure you like the people you've chosen, and make sure your voice is heard. If you don't like the people you've chosen, switch. It's not worth it to tough it out. Whether it's an attorney, get out of that relationship as soon as you can. If you feel this person just isn't the right person for you, if you feel they're not getting back to you fast enough, or if you feel they're not listening to you. Your voice is important. The attorney is there to give you your legal rights, to guide you, but it's your decision how you settle. Do not let yourself be talked into a settlement agreement that simply doesn't work for you. I hope this has helped you. This is so very important to know your options, and to know that if the option you've chosen doesn't work for you, if the people you've chosen don't feel right to you, just move on and choose other people. I appreciate yet again that you've joined me for Constructive Uncoupling. Again, I'm Judy Weigel, your host. I'm in Los Angeles. I'm a legal document assistant and a mediator. I can be reached through my email address, Judy, Judy, at divorceresourceinc.com, divorceresourceinc.com. I look forward to our next episode.